May I please, Your Lordship? Lordship, I beg to mention hearing item number 29, Lordship. Hearing item number 29. If this matter may be listed on Thursday, my Lord. Thursday, Lordship.
Thursday will be
19, Lordship.
Yes.
Much obliged.
May I please, Your Lordship? Lordship, I beg to mention hearing item 23. Lordship, Lordship.
Lordship, this is the POSO matter. It was mentioned. But apparently, I've been informed that Mr. Ezo, getting 23.
Hearing starts only from 25.
Updated to share.
23 is Oriental insurance matters.
I think the cost list has been upgraded, Lordship. We were not aware. I think he's having the old one. It's 26. Item
26, yes. 26, Lordship.
Yes.
Lordship, Lordship. Lordship, I pray may this matter come up after 2 weeks, Lordship. As Your Lordship here, my senior counsel is out of station for his daughter's treatment.
It's a 22 matter.
22
Why
matter,
you
Lordship.
don't want it disposed? It's against conviction.
Lordship,
Yes,
Lordship.
Lordship. As far as I'm concerned, Lordship, I'm ready with the matter.
This is the appellant.
Yes, exactly.
Also, Mr. Ezo is actually makes a mention on
After 2 weeks, a fixed date, Lordship.
Mr. Ezo to release the matter after 2 weeks as he has some medical problems. As the leading counsel has some medical problems. Leonard Pepe is present as well as Mr. N. Muzui in this schedule for the informant.
Respondent.
For the informant slash respondent. So where is the log list?
On 3rd, Lordship. 2nd or 3rd?
3rd March.
3rd March.
Lordship, Lordship.
List on 3/3/2026. Yes.
Oblige, Your Lordship.
Much obliged.
May it please Your Lordship, I am troubling Your Lordship. One matter may be taken up today, my Lord, for motion. Matter relates to, my Lord, Custom Authority. They have seized my goods on the allegation of violation of GST Act. My Lord, they have transferable power of GST, my Lord.
Tomorrow,
have come from outside. If possible, if time
You have
permits,
filed it. Have you filed it?
If time permits, my lord, I will wait. Otherwise,
Okay, let's see.
my,
You just
my, the,
Deputy My Lady. My Lady, I mentioned item 11. In fact, My Lady, I want to withdraw the WPC 182 with liberty to file afresh if so advised.
Council, Mr. Joseph appearing for the petitioner in WPC 182 of 2024.
My Lady.
So it is submitted that he wishes
11 wait.
wishes to withdraw the petition with liberty to file afresh. Very second, petition is disposed of or withdrawn, and the petitioner is given liberty to file afresh. So
Hello, Black.
but 165 will remain.
Yes, 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 Lordship.
This is only for WP 182.
Hello, Black.
Your Honor, I am representing for the respondent number 4 in the present case.
In 182.
Yes, Your Honor.
It's okay. No table.
May I please, Your Lordship, item number 10. I am representing for the respondent number 6. Your Honor, here, with the consent from the petitioner, we made a matter be fixed after 3 weeks.
3 weeks. First, Learning Council for Learning Council, Mr. Research, appealing for respondent number 6, who prays for listing the matter after 3 weeks in order to file affidavit. Or what? Where are you seeking time? Have you filed your affidavit?
Senior is indisposed, Your Honor.
No, that's right. Have you filed your affidavit in opposition?
Yes.
Just say as the leading counsel has some difficulties today. So, learned counsel for the petitioner, Mr. Kohima is present and has no objections. List after 3 weeks. This will be for 165.
Much obliged.
May I please, Your Lordship? Lordship, I beg to mention item 27 on behalf of my senior. Lordship, since my senior is having some difficulty today, kindly list this matter on Thursday.
My lord, if that be the case, let it be listed on 25th, that is Tuesday.
25th is Wednesday.
And 24th.
24th is Tuesday. 26th. Learned counsel.
24th.
Petitioner, Ms. Such and such, who makes a mention on behalf of the leading counsel to list the matter after so learned additional AG, Mr. T. Something appearing for the respondents has no objection and prays for listing the matter on 24 to 2026. 24, list on 24 to yes.
Obliged.
Macho.
My pleasure, Lordship. Lordship, I beg to mention item number 4 on behalf of Vizimo.
On behalf of
Vizimo. He's here to receive instructions, so kindly list this matter after 3 weeks.
petitioner. Item 4,
Yes, Lordship.
it's motion.
Address, Lordship. Lordship, this item 4, Lordship, item 4 with item 12, I may kindly be allowed to withdraw with the liberty to file a fresh, Lordship.
Item 4 with item 12.
Yes. Item 4 and 12.
Council, Mr. Notary Konyak,
Lordship.
hearing for the petitioner, please be allowed to withdraw the petition with liberty to file afresh. The petition is disposed of and withdrawn. Petitioner is at liberty to file afresh. So advice. So this will be same order in 4 and 12.
Lordship. Also, Lordship, I pick to mention item 13, Lordship. Here, with regard to service upon respondent number 4, Lordship, I may kindly be granted 1 week time, Lordship.
1 week.
Lordship.
You have not taken steps.
Lordship.
Council search for the petitioner, please for which time to take fresh steps on respondent number
4, Lordship.
number 4.
Lordship, and item number 17, Lordship. Here, this honorable court order has been complied, so let the matter may be closed, Your Lordship. Item 17.
Yes, Your Lordship, it's been complied.
Then it also for the petitioner, Mr. Nokli Kuya submits that the order of this court in the WPC
WPC number 317
WPC 317
of 2014.
2014 has been complied with and accordingly the matter will be closed. Also, this is Vidika appealing for the respondents.
For all the responses.
17.
Accordingly, the matter is closed and disposed of.
Obliged, Lordship.
May it please Your Lordship, I beg to mention item number 20, Your Lordship. We have agreed for mediation in this matter, Your Lordship.
22.
20. Yes.
So we can refer it for mediation.
Yes, Your Lordship.
Also for the appellant, Ms. Kim Penny, who submits that the parties are willing to refer the matter for mediation. So accordingly, this matter is referred to the mediation for the mediation process. So the parties are directed to appear before the registrar Gauhati Kohima bench, who shall fix a date for the mediation. Appear before the registrar on 18th. Can they come on 18th? Oh, that's too soon. 19th. When can they come? The parties?
I'm for the respondent want to.
So all of them have to
Yes.
come. So give a date. 23rd.
Okay. Yes, sir.
Please the matter after the mediation process is completed.
Much obliged.
May it please Lordship. Lordship, I beg to mention item number 25 on behalf of his Lordship, he still received instruction to the amended writ petition. So can you grant 3 weeks time to file affidavit?
It's already in the hearing list. Reading is not complete.
There is some amended writ
Your
petition.
Lordship, when the matter was taken up, the counsel for the state, they have made a prayer for implement commandant. So,
New respondent.
new respondent. So on behalf of the new respondent, they are here to file affidavit.
You had filed amended petition.
Yes, yes, yes.
Counsel for the state respondent, Ms. Pichani Gita, who submits that the state respondent has to file an affidavit in reply. No, affidavit in
Opposition,
opposition,
Lordship.
in respect of the newly impleted respondent number.
5.
Respondent number 5.
I'm 5, Your Lordship.
6, Lordship. 6, Lordship.
And therefore prays for 3 weeks time to file the same. Learned counsel for the petitioner, Mr. Mohan Jamil is present, as well as Mr. Joshua Shetty for respondent number 5. So there is a doubt list after 3 weeks.
Obliged.
Lordship, item number 26 as well on behalf of visible.
26 is already submitted.
Lordship.
26 is urgent.
For motion, item number 1.
May it please, Your Lordship. My Lord, is a very, very short point is involved, but the brief appears to be very hefty one. My Lord, Your Lordship will find the petitioners here are all poor villagers. Now, my Lord, they have lost their properties in the form of land and houses, building, and then the paddy fields, all these things permanently been damaged in the name of construction of the 2-lane route in the FAC district. Now, my Lord, they were very poor and owing to the financial constraint, they could not come themselves on the last occasion.
But after so long, delay,
I beg your pardon me?
after so long you're coming.
No, no, we have already got some of the relief, but the certain part, that is interest part, that was not given. Your Lordship will find, my Lord, I will take your Lordships to the,
There was one order, I think.
Yes, yes.
Yes, 27/1,
Right.
26 order.
I will take your Lordship to
Where
that.
it says that the CGSC and the Additional Advocate General will submit on the point of maintainability.
Res judicata.
Yes,
My
yes,
Lord.
res judicata.
My Lord, with all respect to Honorable Justice Fukan, my Lord, this concept of res judicata is not at all applicable in this case. My Lord, I will raise the thing with your Lordship, what is the meaning of res judicata and how whether the order affects that. My Lord, first I will take your Lordship to section 11. My Lord, it is better to give the little facts to your Lordship so that your Lordship can get the thing. Now, the order was passed in the PIL.
Yes, this PIL 9 of 19.
Yes, the order was there. My Lord, if your Lordship look at that order at page 659, volume 4, my Lord. That will make the thing very clear. Lord, but it's a short judgment. I will read right from the beginning so that your Lordship will get the facts also.
Page 6.
659. It starts from 659. Order dated 30/1/2023. Your Lordship got it.
Yes.
This is a PIL filed by Chakesham Public Organization through its functionaries on behalf of persons whose lands, properties, including so and so, were damaged due to the construction of two-lane road within FAC district under the two-lane project. Now the para 3, your Lordship can come. The facts and the circumstances leading to the filing of this PIL briefly stated as follows. In order to improve the pathetic condition of the roads in the state of Nagaland, the Ministry of Road Transport and Highways, my Lord, is the central scheme, my Lord. Transport and Highways and the scheme known as Special Accelerated Road Development Program, Northeast allotted a sum of rupees so and so for construction of two-lane road from Longley so and so. Ministry of Road Transport and Highways, the Public Works Department, Nagaland were notified to be the funding and executing agency and the implementing agency respectively. After the tender process, the contractor, namely so and so, was issued the work order and the contractor started executing the work in the year 2011 under the supervision of the state PWD. During the process of the execution of the work, a lot of cut out stones, trees, etc. were piled up along the road under construction instead of dumping the same at the identified dumping sites. Therefore, when the rainy season came, they slid down on the lands and property of the villagers who were settled along the roads, causing severe damage to their lands and properties. Since the landowners are poor farmers and ignorant about their rights and the ways and means to redress their grievances, the petitioner organization took upon itself to help them in approaching the right authorities and forums through legal means so that their grievances are addressed or redressed as per law. So after several meetings were held, the petitioner submitted two representations so and so to the chief engineer and to the deputy commissioner of FAC respectively, requesting for compensation for the damages caused to the properties of the landowners whose lands and properties have been affected during the construction of the road, specifically for the landowners along the stretch of the road, namely FAC 40 and Junegoto, under the administrative jurisdiction of so and so. Though the representation did not receive immediate response as desired, the office of the PWD National Highway Nagaland conducted a joint survey of the land and properties damaged and destroyed for the purpose of ascertaining the extent of damage caused to each individual land and properties and for the purpose of qualifying the compensation to be paid. The same was carried out under the aegis of the Deputy Commissioner and whose jurisdiction the properties are situated. The joint verification was conducted by the officers of the state, aggrieved persons, and the members of local administrative bodies after issuance of proper notification by the Deputy Commissioner concerned. As per the joint survey, the compensation amount worked out of the landowners between so and so. However, the state government of Nagaland did not disperse the amount to the landowners on the ground that the state PWD was only the implementing agency and the project is fully funded by the central government, more particularly Ministry of Road, Transport and Highways. Therefore, unless the fund is released by the ministry concerned, the state government will not be in a position to pay the same. Meanwhile, the contractor asked the escalation of the contract amount. However, the same was refused by the employer. Due to the tussle between the employer and the contractor, the execution of the work stopped. The parties went for arbitration for settlement of their dispute. While this was going on, the petitioner filed the present writ petition praying for issuance of appropriate writ order direction directing the respondents, more particularly the Ministry of Road, Transport and Highways, to pay the compensation as worked out by the state government after the joint survey was conducted. There is no denial as to the claim of the petitioner that damages were caused to the land and properties of the landowners whose lands are situated within the administrative jurisdiction of the EEC, FACT district, and no question has also been raised on the quantum of compensation worked out by the state government following the joint survey. The only plea taken by the state government is that it is a project funded by the Ministry of Transport and Highways, and the state is only an implementing agency. Therefore, the compensation ought to be paid by the state ministry. On the other hand, the union stand as submitted by the learned CGSC is that the compensation should be either paid first by the state and make their claim from the ministry or claim the same in the arbitration proceeding which is still pending. Since there is no dispute from the side of the respondents on the claim of the petitioners that lands and properties of persons whose lands are situated below the road in question and which are within the administrative circle of the EEC were damaged or destroyed, the need for a discussion on the claim does not arise. Record shows that the project for construction of 2 lanes from 40 Longlang, within which the lands and properties of the farmers or villagers for whom the writ petition has been filed, was initiated and fully funded by the central government. The state government is only the implementing agency. Further, record shows that the compensation have been paid to the owners of the lands situated above the road which were affected by the construction of the road. Therefore, it appears that the problem of paying compensation to the owners of the land situated below the road for the damage or destruction caused to their lands and properties has arisen either due to lack of knowledge about the terrain along with the road was to be constructed or ground realities or failure to envision the most probable consequences that may follow during the construction. Had the planners been made aware about all these while conceptualizing and preparing the final detailed project report, they would have been taken the same into account, and the poor landowners would not have had to go through all these ordeal of running from pillar to post for compensation of the loss suffered by them. No hindrance on the construction of the road would have been caused at the same time. When compensation has been paid to owners of the lands whose lands lie above the road, there is no reason why owners of the lands and properties whose land lie below the road and are also affected by construction of the same road should not be entitled to receive the same. It is true, Your Lordship, kindly give an emphasis on that. It is true, right to property is no longer a fundamental right, but when property of a person is affected or damaged while undertaking a public related project, and if such person is not compensated adequately, Your Lordship, kindly give an emphasis this word, adequately, the consequence is his livelihood is affected, and that would lead to violation of his right to life protected under Article 21. Therefore, in this case also, though the private landowners whose land lie below the road constructed have no right to say no to the construction of the road and acquisition of their lands, they have a right to be compensated adequately for their lands, properties, standing crops, trees, etc., affected with the construction of the road. or not to do so violate their rights protected under the said article. In fact, the landowners being tribal and marginal landowners, the authorities, be it from the central government or the state government or both, should have been a little more sensitive and considerate, if need be, while undertaking the project so that they need not have gone through such loss and suffering. The project started in the year 2011, Your Lordship, kindly see, it started in 2011 and the compensation was paid in the late 2024 and early 2025. So there is a huge delay, almost 10 years. My Lord, the Honorable Court has already marked. Therefore, it has been more than 10 years since the owners of the lands have suffered the loss of their lands, crops and properties. A welfare state certainly is not expected to be so apathetic about the genuine grievances of its own citizens. It does not behave for a welfare state to deny or defer benefit of such right by giving such excuses that the landowners may make such claim in the pending arbitration process, especially when the landowners are not a party in the proceeding. Therefore, to prevent any further suffering of these people, both the central government and the state government should act in tandem expeditiously. Admittedly, Your Lordship, kindly see here, admittedly the damage caused to the lands and properties have been already assessed by conducting a joint survey, and even the quantum of the compensation amount to be paid has also been determined under the leadership and supervision of the Deputy Commissioner concerned. As such, the state government shall make the first move by submitting a proposal along with the assessment made to the central government ministry concerned, and on receipt of the same, the latter shall initiate the process for allocation of fund and release of the same to the state government, who then shall disburse the same through the Deputy Commissioner of the district concerned to the genuine landowners whose lands, properties, standing crops and trees, etc., have been damaged or destroyed during the construction of the road. The whole exercise should be completed within a reasonable time, but not beyond 6 months from the date of this judgment. Your Lordship, kindly visualize one thing. This order, court has passed an order to the authority, central government specially, my Lord, to demarcate what will be the determination of the compensation. Now, here the compensation includes interest. Now, the question of res judicata will come. The learned judge has thought, since the compensation has been said to be given, so there is a determination, even the question of interest. My Lord, that is totally, my Lord, I would say.
So after this, what happened?
Then after that, my Lord, they have paid the amount in the latter part of the 2024 and the early part of 2025. Now, Your Lordship will see that at page 667. Your Lordship will find that this is the letter dated 27th October 2023. It's to the Commissioner. I am directed to refer to sanction a letter number so-and-so, dated so-and-so, and to convey the administrative approval, technical approval, and financial sanction of the President of India for the payment of award based on the order of the Honorable Gauhati High Court, Kohima bench, dated so-and-so, regarding damage compensation amounting rupees so-and-so. Then amount shall be recovered. Now, this, as Your Lordship has seen, it was sanctioned in the year 2023. And the amount Your Lordship will find, Your Lordship can see volume 3. Please. Your Lordship kindly see type of damage at page 378, volume 3. This was, assessment was made on 27 February 2017. The amount, my Lord, Your Lordship will find, in the amount column, Your Lordship will find 60 crores 94 lakhs 36,000 and odd. Now, detail has been given. Now, this was worked out in the WEBEC in 2017. The payment was made on late 2024 and early 2025. Now, what we want, my lord, the prayer is the the court has said adequate compensation. Now there are plethora of judgment of the appeals court. Compensation includes interest. My lord, I will take your lordship to that now.
So what you're trying to say is,
Yes.
this assessment which was made in 2017,
Yes.
this amount only was given to you? Yes.
Yes, my lord. Now, regarding interest, my lord, your lordship will understand in every sphere of any sort of cases, whether civil or land acquisition or motor accident cases, interest is a consequential relief. Interest is implied. So therefore, how question of res judicata comes, I just fail to understand. Therefore, just for a while, your lordship kindly see section 11 of the CPC. By no stretch of imagination one can say that it will attract section 11 of the CPC. These are, my lord, unnecessary issue. We shall be delaying the matter. My lord, it is not necessary for any sort of adjudication. Section 11, your lordship can
So
see.
it was not a question of acquisition?
Not at all, my lord.
Damages only?
Damages already been paid, but interest comes for delayed payment, my lord. Lord, appeals court has said if you make any delay, because now, your lordship, it can be treated as if it is a deemed acquisition. Now, if it is a deemed acquisition, you are required to pay the amount of interest at the rate of 9% if you do not pay within 1 month of the, if you pay within 1 year of the acquisition, 9%, beyond 1 year, 15%. This is the straight jacket formula, my lord. There is no need for any sort of argument on that. Now, whether res judicata attracts or not. Now, your lordship kindly see, no court shall try any suit or issue in which the matter directly and substantially in issue has been directly and substantially issued in a former suit. That means earlier PIL. Between the same parties or between the parties under whom they or any of them claim litigating under the same title in a court competent to try such subsequent suit or the suit in which such issue has been subsequently raised and has been heard and finally decided by the court. Now, regarding, my lord, your lordship has seen the order passed by this honorable court. Honorable court has said, pay adequate compensation. Now it is up to the authority. Authority will have to work out in accordance with the law. Now, when the phraseology is adequate compensation, is up to the authority. You work out, and if you did not pay within 1 year, in that case 9% interest. If it is beyond 1 year, 15% interest. Now, this sort of thing was never determined by the single judge in the earlier occasion. So how come it will have to be finally decided? Now, how this question, where this question was decided? So, my lord, this maintainably point came from the honorable judge. I don't think, my lord, it attracts section 11. And I take your lordship there. So
PIL would only said adequate compensation.
Adequate compensation to the authorities. And these so far we are arguing on interest part is a totally fresh cause of action, is a new cause of action. Because the authority did not work out in that manner, which they ought to have done.
So according to you, the interest should have been calculated from 2017?
No, my lord, right from 2012.
From the time when it was assessed?
They have worked out in 2017, but then damage took place in 2011. So therefore, they are entitled to get, my lord, in land acquisition cases, what happens? The moment they acquire the land, they will have to pay interest. If you pay within 1 year of taking the possession, then you will have to pay 9% interest. If you cannot pay within 1 year, then, my lord, 15% interest. These are, my lord, in the statute it has been enumerated. And this is, my lord, there is no doubt, admitted fact that the permanent deprivation of the property is taken place here. So question of res judicata is unnecessary to take up the matter because there is no concept of res judicata in this case. because it was never decided finally.
Yes, what do you say? Is it for the central government?
Here, my lord,
Notice, sir.
CGSE on behalf of Union of India is nodal department.
No, regarding the maintainability, what do you say? Because in the PIL,
Yes,
the court only decided about the that they entitled to the damages.
Yes, ma'am.
And said adequate compensation. So it did not enter into how much interest, and the interest should be counted from when. All those things were not considered.
While filing,
So res judicata, I don't think.
the present petitioner, along with the CBO, instituted the writ petition before this honorable court, I mean the PIL, numbering PIL 9 of 2019, on the ground that they were deprived of damage compensation. Therefore, by 30th January 2023, the petitioners, along with the similarly situated persons who were before this honorable court, have been adequately compensated by awarding
Yes, that I have seen.
60 crore 94 lakhs
But now
36,685.
what they're saying is only that assessed amount 2017, that was paid without any interest. So now this petition is for the interest only.
My lord, in the PIL 9 of 2019, no mention is made about the rate of interest. Nothing was mentioned. Now, regarding res judicata, they have approached this honorable court twice for the same cause of action. They approach this honorable court by filing PIL 9 of 2019, and thereafter they are approaching this honorable court for land compensation, which is more or less approaching this honorable court after thought.
PIL 9 of 19, then after that?
2019.
So this is the second one.
Second.
No, but the question here is compensation, whether that includes interest or not. That is the question to be decided.
In tier first PIL 9 of 2019,
Adequate compensation.
the present petitioner along with the CPO have never demanded for claiming the rate of interest starting from 2012.
No, but that is the point to be decided, not in this petition.
Let the CGSE,
Whether that will
on behalf of the
include
Union of
interest or
India,
doesn't include interest.
make their submission, my lord. CGSE on behalf of Union of India.
Yes.
Please, Your Lordship, I'm appearing on behalf of my senior. He's indisposed today, so we're yet to receive any instructions.
Will you issue notice then at this?
My lord, at this stage, notice may not be issued.
Why?
We will be filing our objection.
My lord, at this stage, your lordship may admit it.
Will issue notice. Third Learned Counsel, Senior Counsel, Mr. S. Datta, assisted by Mr. S. Sharma for the petitioners. Also with Mr. L.T. Sankan for respondent number
5, 6, and 7.
5, 6, and 7. And Ms. Such and Such appearing for on behalf of Mr. Gauhati for respondent number 1, 2, 3, and 4. On 27/1/2026, when this present petition came up for the first time, this court had passed an order that the issues involved in this petition are found to have been adjudicated by this court in PIL number by the division bench in PIL number 9 of 2019.
PIL was before single bench. Division bench
in PIL 9 of 2019, and that the issue of interest had already been adjudicated by the court, and therefore the question as to whether a subsequent writ petition on the same issue is maintainable, and whether the constructive res judicata would stand in the way of the present writ petition was raised by the state respondents. So, accordingly, the court had directed the respondents to address this issue, especially on the point of maintainability of the present petition. So, Third Learned Senior Counsel, Mr. Datta, on the issue of maintainability, and he has taken the court through the contents of the judgment and order dated such and such in BIL number, I will just keep the date later, BIL number 9 of 2019. You want to raise objection regarding the maintainability?
Yes.
Well, the state has no role to play because they're the implementing authority. They are not going to pay.
The main respondent is the
Union of India.
Union of India.
Let the Union of India also make their submission before admitting it.
Okay, we'll keep it open.
Well, in fact, my lord, possibly I could persuade your lordship that there is no question of res judicata. So, my lord, why you should?
Want to file an objection? Let them file. Give them an opportunity. It's okay. Issue notice reasonable within 4 weeks. So the learned, since the respondents have already entered appearance, no formal notice is called for. So the issue of maintainability is kept open, and the respondents shall file their objections / affidavits before the next date. Okay. Please after 4 weeks.
All right. My lord, even what my submission would be, your lordship will find the poor people, how the government is exploiting them. Even it is not under any land acquisition act. It is, they made their own formula. It should come from even the court, my lord.
The only thing is, the opportunity should be given.
Yes.
For motion, item number 2.
May I please, your lordship? Lordship, this is a 528 application for quashing of criminal complaint case number 5/25 under section 138, reduced section 143 of the NI Act, pending before the CJM Kohima. Lordship, may I please peruse page 14, Annex 1. Page 14, para 3. May I read, lordship?
Yes, please read.
That the complainant most respectfully begs to state that accused number 1, Rashid Ahmed Chaudhry, is the proprietor of Royal Bricks Industry situated at Nulua, Kamalpur, PO Jalal Nagar, PSN district, Karimganj, Assam. And accused number 1 borrowed a sum of rupees 5,50,000 from the complainant on 14/9/2021 for enhancement of his business of bricks, with the condition that accused number 1 would either give 1 lakh pieces of bricks or equivalent of 1 lakh pieces of bricks per existing market value to the complainant within 30/5/2022, and be it mentioned that aforesaid payment made by the complainant through banking system transaction ID so and so in favor of accused number 2, Zakir Hussain Chaudhry, on dated 9/11/2021, being the agent of accused number 1. After bank transfer of the aforesaid amount, the accused number 1 has acknowledged the receipt of 5,50,000 from the complainant over telephone. My lord, may I please peruse page 15.
Yes.
Page 15, para 6. That the complainant begs to state that once again visited and met both the accused person and asked both of them, as being the proprietor as well as agent of Royal Bricks Industry, to return the amount and complete the contract of providing 1 lakh pieces of bricks or equivalent price of 1 lakh pieces of bricks as per existing market value. Then the accused number 1 issued a check dated 17/1/2025 bearing check number so and so, account number so and so of HDFC Bank, Karimganj Main Road branch in the name of the complainant's business shop, Glamour Cosmetics, in order to discharge his liability. So, my lordship, my humble submission is that I am not the signatory of the check. Neither I was in debt of the complainant. The complainant paid the amount to accused number 1 so that he may receive some amount or the bricks. But I have no role in this transaction. In this transaction, I am just a mediator or witness. It is like that.
No,
So,
but
my lord,
accused number 1 issued the check.
yes, accused number 1. I am accused number 2.
Oh, okay. And who is accused number 2? Zakir.
Moreover, my lordship, in my reply to the legal notice, page 26, if my lordship may peruse, I have clearly mentioned it to page 26, para 2.
Yes.
That your client Ahmed Hussain Tapadar and Rashid Ahmed Sodri, receiver number 1, was known to my client since long time. It is not a fact that my client Zakir Hussain Sodri was the agent of notice receiver number 1. Rashid Ahmed Sodri, as stated in para number 2 of your notice, hence my client expressed strong exception against the use of words agent of addressee number 1. That my client was present in the time of talk between your client and Rashid Ahmed Chaudhry, that both your client Ahmed Hussain Tapadar and addressee number 1 Rashid Ahmed Chaudhry on being agreed in connection with the transaction to send the said money in the account of my client as mediator, to withdraw the same and to hand over to the addressee number 1, Rashid Ahmed Chaudhry, and accordingly after sending, my client handed over the said amount of rupees 5,50,000 to the said addressee, Rashid Ahmed Chaudhry, which was duly received and acknowledged by the said Rashid Ahmed Chaudhry. So, my lord, I have made my point very clear. I am not in debt, and there is no thing such as vicarious liability in NI Act. Vicarious liability only applies in the case of companies. So, my lord, I may be granted interim protection and stay may be granted in the proceeding concerning the petitioner.
Who's appearing for the state response?
State have a limited role.
Yes.
Yes.
But going through the FIR, it appears that the signatory was not the present petitioner.
Yes, madam.
Signatory of the check who is liable.
Signatory was accused number 1.
The present application under section 528 of the BNSS has been filed by the petitioner, Mr.
Zakir Hussain Chaudhry.
Praying for quashing of the criminal complaint case number 5 of 2025 under section 138, read with section 142 of the Negotiable Instruments Act, pending before the Chief Judicial Magistrate, Kohima. Stop. I have heard learned counsel for the petitioner, Mr. Your name?
Yunus Khan. You Khan.
Also heard Ms. Mary, learned public prosecutor for respondent number 2. The petitioner hearing submits that the impugned complaint dated there is no date. The impugned complaint filed by the respondent one, filed by the respondent one, has implicated him complaint was page, the complaint,
Complaint was on page 12.
is what did I say last time? Implicated him as the agent of the accused number one, and that he had issued a check for an amount of rupees 5,50,000 in favor of the complainant slash respondent one, which had bounced, and therefore which had bounced. So the petitioner also submits that he is not the signatory of the check number 000040, okay, 92, issued to the complainant, and that it was the accused number one. What is the name of the accused number one?
Rashid
Number one slash
Rashid Ahmed Chaudhry.
Chaudhary, who had issued the same, and therefore the present petitioner has no liability, and that the case and that the complaint case could not have been filed against him. So, issue notice written within 4 weeks. The petitioner shall take steps for service on the respondent number one by speed post document as well as review service usual process within 3 working days. So, public prosecutor has already entered claims on behalf of respondent number two, hence no formal notice is called for. So, list after 4 weeks. In the interim, the complaint case number 5/25 pending before the Chief Judicial Magistrate Kohima shall remain suspended in as far as the present petitioner is concerned. Yes.
Obliged, my lord.
For motion, item number 3.
Please, Lordship. Lordship, the present petition is filed in non-compliance of court's order dated 4/4/2025. My Lord may find the court's order in page 12 as Annexure 1.
What is the direction?
To regularize the petitioner's service within 4 months, Lordship. Lordship, the relevant para starts from page 16, para 6.
Counsel for the petitioner is the present contempt petition has been filed under section 12 of the Contempt of Courts Act, read with Article 215 of the Constitution of India, alleging willful non-compliance of the order dated 4/4/2025 passed by this court in WPC number 316 of 2023. Learned counsel for the petitioner submits that the writ petition was disposed of, directing the respondent authorities to take effective steps for the purpose of consideration of the petitioner's case in terms of the office memorandum dated 5/3/2025. Isn't it 5/3/2025? It is submitted that in spite of such direction, the respondent authorities are yet to take any steps. Especially when this court had directed the respondents to comply with the order within 4 months from the date a copy of the order was served on the respondent number 3. It is stated that the order of this court dated 4/4/2025 in WPC 316 of 2023 was served upon the respondents on which date?
16/4/2025.
16/4/2025. Issue notice returnable within 4 weeks. The petitioner shall take steps for service on the respondents number 1, 2, and 3 by speed post document as well as usual process within 3 working days from today.
For motion, item numbers 5 and 6.
May I please, Lordship? Lordship, this IA is filed praying for implementation of Shri Abhijit Sinha IAS, the Home Commissioner, Lordship, the new incumbent or Commissioner, Lordship, in the contempt petition 24 of 2025, Lordship. While during the pendency of this contempt 24/25, Lordship, the officer in charge has been transferred and the new incumbent officer has taken charge. So if the new incumbent officer can be implemented as a respondent number 6, Lordship.
The present application has been filed praying for implementation of Shri Abhijit Sinha IAS as respondent number 6 in the connected civil original contempt petition number 24 of 2025. Stop. Learned counsel for the petitioner submits that the civil original contempt petition number 24 of 2025 is pending before this court, and during the pendency, the respondent number 2, Shri Vyasan R. IAS, has been transferred out, and the new incumbent, Shri Abhijit Sinha IAS, has taken charge of the Home Department, and therefore it is prayed that the new incumbent may be implemented as respondent number 6 in the contempt petition number 24 of 2025. Stop. Having considered the prayer and submissions of the learned counsel for the petitioner, and after going through the pleadings, the application is allowed. So the petitioner shall take steps to implement the respondent implement Shri Abhijit Sinha IAS as the respondent number 6 and file an amended cause title within 1 week from today, and thereafter takes steps for notice on the newly implemented respondent within 3 working days. So petition stands disposed. Then in the new in the main COP, you say the petitioner has been allowed to take steps for implementation of respondent number 6 of a new respondent number 6. Accordingly, list the matter after 2 weeks.
Much obliged, Lordship.
For admission, item number 7.
Please, Your Lordship.
This is still pending.
Yes, on the last date, that is by order dated 19/1/2026, the proposal has been sent to appoint Sri Kapikoza, retired district and session judge. We do not know whether the report has come or not, my lord.
Yes, I think the report has come. Consent, na? Consent
Yes.
and disclosure. Okay, then we will pass the order.
My lord.
Learned counsel for the petitioner, Mr. Joshua Sheki is present. Mr. N. Nangami, learned senior government advocate, is present for the state respondents. 2 and 3. 2 and 3. And then
The union.
CGC.
Mr. Yangarwati's junior was here earlier.
But on the last occasion, they also agreed, isn't it? So what did
Yes,
they
Your
say?
Lordship. In fact, this Honorable Court disagreed with the stand of the union of trying to wash off their hands.
Yes, I remember this. But someone has to represent, no? Just call the lady who was here earlier appearing for Yangarwati.
Yes,
Learned
ma'am.
counsel, Ms. Such and Such, appears on behalf of Mr. Yangarwati, learned CGC. Stop. Para. By order dated 19/1/2026, this court had directed the registry to communicate with Sri Khape Koza, retired district and session judge, to ascertain his willingness to act as an arbitrator in the present dispute, and to furnish the disclosure under section 12 clause 1 of the Arbitration and Conciliation Act 1996. Stop. Para. A letter dated 9/2/2026 has been, yes, please give your name. Letter dated 9/2/2026 has been received from Mr. Khape Koza, retired principal district and session judge, expressing his willingness and consent to be appointed as an arbitrator in the case. Stop. He has also disclosed that he does not have any past or present relationship and neither any interest in any of the parties involved in this matter. Stop. Accordingly, this court appoints Sri Khape Koza, retired district and session judge, Nagaland, as the sole arbitrator to adjudicate the disputes between the parties. Stop. The learned arbitrator shall enter upon reference and conduct the proceedings in accordance with the provisions of the Arbitration and Conciliation Act. Fees and venue, I'll leave it to you.
My lord.
The fees and venue shall be decided by the arbitrator in consultation with the parties concerned. Para. The registry is directed to send a copy of this order to the arbitrator as well as to the parties, and thereafter, after arbitration, will it come back to the court? I'm not very sure about this.
Your Lordship,
It will not come
if
back.
the decision is
So
to be
this-
challenged, it will go to the
This record
district
has
court.
to be given to the arbitrator.
Yes, Your Lordship.
And the registry shall also transmit the case records to the arbitrator.
Within specified time, we may be allowed to approach the.
Yes, the parties shall appear before the arbitrator. When do you want?
Lordship, within 30 days?
Before the arbitrator, within 30 days from today. Yes, that will do.
Blush, Your Lordship.
Obliged. For admission, item number 8.
Lordship, on the last occasion by order dated 19 January 2026, an observation was made that the LCR is yet to place on record.
Oh, yes. Trial court record has come. Not come. Which court is it?
District and Session Judge Twinsang.
Twinsang.
Yes.
Oh. Learned Counsel for the petitioner, Mr. Moy Jamir is present. Stop. On 19/1/2026, this court had directed the registry to issue a reminder to the Learned Trial Court to transmit the case records. Stop. When the matter is called, it appears that the trial court records are yet to reach. So accordingly, the registry shall issue another reminder to the Court of District and Session Judge Tuinsang to transmit the records expeditiously. So please, after 3 weeks.
Obliged.
For admission, item number 9.
Yes.
May I please, my lord? Lordship, I am appearing for respondent number 2 and 5 in this contempt matters. I have filed my affidavit showing the steps that have been taken, Your Lordship. Now, Your Lordship, after this, the PNR will place the proposal before the MRC. And after getting the approval from the MRC, it will be placed before the Cabinet for the final decision, Your Lordship.
For regularization?
Yes, for regularization, Your Lordship. This is the step that has been mentioned in the office memorandum, my lord.
What are they? Their work charge?
They are work charge, my lord.
This is in terms of the scheme, isn't it?
Yes, correct.
So in terms of the scheme, it has to go up till the Cabinet?
Yes, it has to go up till the Cabinet. Then only after the Cabinet gives its approval, the department can issue the regularization orders to them, my lord.
Yes.
Yes, my lord, here, respond.
It is now before PNR.
Yes, Your Lordship, which will be subsequently placed before the MRC. Then, MRC, after getting approval from the MRC, it will be placed before the Cabinet.
But why are they taking so long?
Lordship, in fact, on earlier occasions also it was once placed before the MRC, but certain anomalies was detected by the MRC, so it was sent back to the department. The department has rectified those anomalies and has sent it back again, Your Lordship. I have mentioned everything in my affidavit, Your Lordship.
Your affidavit on behalf of respondent
2 and 5, my lord. I am the secretary, Your Lordship.
Secretary PHE.
Yes, my lord. Your Lordship may kindly come to page 10. Here, page 10, Your Lordship. Here, from the MRC, it was returned back. It was returned back with a recommendation, Your Lordship, on the second para.
The committee examined
Yes, PNR and finance clearance and recommendation of creation of one to regularize the employment in respect of Sri such and such under the establishment of PHED as per the Department Office Memorandum dated 17/3/2015. The post shall stand abolished on retirement. So one post was already regularized and the remaining, Your Lordship. For the remaining posts, Your Lordship, the department has asked to re-examine whether due procedures were fulfilled in respect of all the work charge employees and resubmit the proposal with strong justification, Your Lordship.
This is August 2023.
Yes. Thereafter,
now we're in 26.
Yes. Thereafter, Your Lordship, we have done the necessary rectifications again and send it back. Send it back, Your Lordship. Your Lordship will find it at page 12 again. This is again creation of 19th post of work charge employees under PHE department. Again, we have done all the necessary clarifications and then we have sent it back, Your Lordship, to the PNR. This is 29 July 2025 again, Your Lordship. Everything has been rectified. We have sent it back, Your Lordship.
Then after that, creation of...
Yes.
Oh, this is the cabinet member.
Yes, Your Lordship. Only after the cabinet gave its approval, Your Lordship, we can issue the regularization order.
Okay, so now it's pending before the cabinet.
It is pending before the MRC, which will be, yes, which will be subsequently placed before the cabinet, Your Lordship. This is the,
It has passed the MRC, that's why this memo is made.
no, Your Lordship, in fact, MRC has declined it, and therefore we have again reprocessed the entire thing, Your Lordship.
After this September 2025,
Yes.
again reprocessed.
No, Your Lordship. This particular office memorandum is prepared to be placed before the MRC again.
Oh, okay. Creation of 18 supernumerary posts. 18 posts.
Yes.
So these are all the petitioners.
Yes, these are all the
18 of them.
petitioners. Yes, my lord. Your Lordship will find the list. I have annexed it
Okay.
in page 7.
Let's see, we'll give you some more time, but then after 4 weeks,
Yes.
and within that time, you try to comply. Learned Counsel, Mr. S. Walling is present for the petitioner. Learned Counsel, Mr. N. Angami, appearing for respondent number 2 and 5, has submitted on the basis of the affidavit filed on their behalf that necessary steps are being taken by the respondents and there is no willful disobedience of the order of this court. So it is stated that according to the latest update, the memorandum dated, this is September 1, the memorandum dated 1st September 2025 has been prepared for creation of 18 supernumerary posts of work charge employees under PHE department, which is being proposed to accommodate the petitioners.
Yes, ma'am.
Stop. And he has submitted that the memorandum has been placed before the Manpower Rationalization Committee, and thereafter it will be placed before the cabinet for its approval. Stop. He has therefore submitted that the matter is under active consideration and will take some more time. Stop. He has accordingly prayed for how much time?
4 weeks time, my lord.
4 weeks time to comply with the direction of this court. So this is the matter after 4 weeks.
I'm deeply obliged.
For orders, item number 14.
Lordship, I'm appearing on behalf of my senior and Longkumar for respondent number 3. We are yet to file our Vakalatnama.
R3.
Yes. If 3
None
weeks time
appears for the petitioner when the matter is called. Stop. Learned Counsel Ms. Kim Penyu appears for on behalf of Mr. N. Longkamar and submits that he will be entering appearance on behalf of respondent number 3 and prays for
3 weeks
3
time.
weeks time to file his Vakalatnama and necessary affidavit and the affidavit in opposition. So Learned Counsel Mr. N. Nangami appears for respondent number 1.
Yes.
You have filed your counter?
No, Your Lordship.
And prays for
3 weeks time.
3 weeks time to file his affidavit. Oh, you're for the petitioner?
Yes.
Okay. Your name?
Jamubai Gigon.
Just put his name. Don't say none appears. No? Wait for the petition. They are asking for some time. Prayers allowed. List after 3 weeks. 3 weeks or 4 weeks? You
3
said.
weeks,
14 and 15 same.
15 also same.
Yes.
Okay. There also you are appearing.
Yes, for respondent number 3.
There also 3.
Yes.
And you're there also for 1. Okay, same order. After 3 weeks.
For orders, item number 16.
This is also contempt. So many contempt matters. What's happening?
Lordship, here I am for respondent number 1 only, Your Lordship. For the other respondent, I have no instruction.
Here also you are complying, yet to comply. What happened? What's happening? Regularization. This one also.
My lord.
This one also regularization.
Respondent 2 to 5, they are yet to appear. on the last occasion, notice was awaited.
Learned Counsel for the petitioner, Mr. S. Walling is present. Stop. Learned Counsel, Mr. N. Angami is present for respondent number 1. Stop. Service report in respect of respondent 2, 3 and 5, is it? Or 4 also?
2 to 5, yes.
2, 3, 4, 5 is still awaited. Stop. List the matter after 3 weeks, awaiting service report in respect of respondents 2 to 5.
Obliged.
Obliged.
For orders, item number 18.
My lord, here also.
1 to 3
yes,
still awaited.
yes.
Learned Counsel for the petitioner, Mr. S. Walling is present. So the service of notice upon respondent number 1 to 3 is still awaited. So list after 3 weeks, awaiting service report on respondent 1 to 3.
Obliged.
For orders, item number 21.
Your Lordship, in this matter, we will not be sending the matter for mediation, Your Lordship. We have not agreed.
Not agreed, but
Yes.
okay. Learned Counsel, no, just say counsel for both the parties submit that they are not willing to refer the case for mediation. Stop. Accordingly, list this matter. Otherwise, what stage is it?
It's in orders. Respondent number 5 and 6 is still awaited.
Accordingly, list the matter after 3 weeks, awaiting service of notice upon the respondents number
5 and 6.
5 and 6. Stop. Yes.
Much obliged.
For orders, item number 22.
Oh, Mr. Medovero appears for R1. For R1.
Obliged, Lord.
2, 3. Then this
Your Lordship, for R1 to 5.
Yes,
Respondent 1 to 5.
respondent number 1 is representing 2, 3, and 4. 2.
Okay. So the notice on
5 and 6.
5 and 6 is
yes,
not complete.
Yes.
And you are for 1 to 4.
Yes.
Okay, 1 to 4.
Much obliged, Lord.
Our Lordship, even in this matter, the applicant are not ready for.
Not ready.
Yes.
The counsel for the appellant, Ms. Kim Penyu, submits that the appellant is not ready to refer the case for mediation. So accordingly, list after 3 weeks, awaiting service report
For 2 and 3.
for respondent 2 and 3.
Obliged.
For orders, item number 23.
This one also not
Yes,
not
yes,
ready.
yes, yes, Your
Learned
Lordship.
Counsel Ms. Kim Penyu appears for the same order that they are not ready to refer the case for mediation. So please, after 3 weeks, awaiting notice on respondent number 2, 3 and 4. No, 1, 2, 3 and 4.
1, 2, 3, 4, and 5, Your Lordship.
1, 2, 3, 4 and 5.
Yes, Your Lordship.
By the way, respondent 1,
Yes.
it has returned unserved with remark insufficient address.
No, Your Lordship, respondent number 1 is representing 2, 3.
No, that's why it has returned unserved. Insufficient address. You have to take steps to ascertain. And before saying awaiting, you just say the office note dated 16/1/2026 indicates that notice upon respondent number 1 has returned unserved with the remark in inverted insufficient address closed inverted commas. Stop. The appellant shall ascertain the correct address and take steps accordingly.
Obliged, Your
This
Lordship.
after 3 weeks.
For orders, item number 24.
May I please, my Lord? Lordship, I have instruction to appear for respondent number 1, my Lord.
One.
Yes.
Learned Counsel for the petitioner, Ms. Esther is present. So, Learned Counsel, Mr. L. Nangami submits that he has instructions to enter appearance on behalf of respondent number 1 and prays for 3 weeks' time to file his wakalatnama as well as the affidavit in opposition. So, the return service reports in respect of the rest of the respondents is still awaited. So, at least after 3 weeks.
May I please, Your Lordship?
Yes.
I beg your indulgence, Your Lordship. Here in paragraph 7, 8, and 9, Your Lordship, there is some typical error, Your Lordship. The judgment is 17/4/25. However, it's written only 7/4/25, Your Lordship. At page 6, Your Lordship, para 7, third line, Your Lordship. By judgment and order dated 7/4/25. It's actually 17, Your Lordship. So, if I may be allowed to correct it, Your Lordship, by inserting relevant pages, Your Lordship.
Okay, it's just a typographical error. The learned counsel for the petitioner submits that there is a typographical error in paragraph 7 of the petition.
7, 8, 9.
7, 8, 9.
As well as in the prayer section also.
And the prayer portion of the petition, wherein instead of
17/4/2025,
17/4/2025, it has been typed as 7/4/2025, and therefore it is prayed that she may be allowed to make necessary corrections. So, is it allowed? You have to file amended petition, I think, no?
Yes, as per the
Yes. The petitioner is therefore allowed to file an amended petition by substituting the correct date of the judgment. Yes.
Much obliged.
Rejected. But there's one hearing is enough. We'll continue the hearing.
For hearing, item number 28.
This matter pertains to land compensation, and that's constructed by the railways, Northeast Railway Frontiers. So Railway Council is represented by Mr. Harish Gupta. Apparently he is attending a different matter online. So if
Not YP Gupta.
Harish Gupta from Gauhati Principal Seat.
And what about this? What handover copy of the records?
Yes, we have received.
You have received.
Your Honor, I am appearing on behalf of Harish Gupta.
We cannot see you. To the CGC also you have served?
Yes, my lord, yes.
Okay. Yes. When do you want? Now your audio is not.
He has told me over the phone that it can be listed on Thursday if it's convenient for this honorable court.
Thursday.
19.
Okay. Learned counsel for the petitioner, Mr. Moa Jamir is present. So, learned government advocate, Mr. E.T. Papong is also present. However, it is submitted on behalf of Mr. H. Gupta, learned CGC, appearing for the railway authorities, that he has some personal difficulties today, and accordingly please for listing the matter on 19/2/2026. So, list on 19/2/2026 for hearing.
Obliged. Much obliged.
For hearing, item number 29.
'29 is already mentioned, isn't it? I think it's mentioned. '30 is there.
For hearing, item number 30.
May I please, my lord?
Yes.
Your lordship, the petitioners are seeking for service regularization. here there are two petitioners here, and then petitioner number 1, in short, my lord, in the evidence and possession filed by the state respondents, they clearly stated that petitioner number 1 is covered by the office OM, 17 to 2015. And then the petitioner number 2, they are taking the stand that though the petitioner was on scale B, he retired prior durations of 2015 office memorandum.
Okay.
And then secondly, he was retired in the year 2011. So in Delhi, they are objecting on that 2 ground.
Both work church, their employees employed into the Department of PhD within 30 years of service.
My lord, here, in short, I'll give a brief description regarding the petitioner number 1, since the petitioner number 1 did not have any objection to state respondents. Petitioner number 1, he was appointed as work charge labor under the establishment of executive engineer PhD with effect from 10/5/1987. Annexed to 1 page 11, my lord. This is the ID card. I've made a type copy also. It annexed 1 page 12. The type copy page 12. Dear,
But where is the appointment order?
appointment order is not available, my lord.
Not available.
Yes, but then in the ID card, it's already stated the date of first joining. It's serial number 5, date of first joining, then 5/1987. As workshop Scala C. And then by office order dated 15/1/2020, that is annexed to page 13. The petitioner was upgraded to workshop scale Kala C with effect from 1/1/2020. And then after serving for 35 years at Annexure 3, that is office order dated 30 May 2022, page 15, passed and issued by the PHET, the petitioner was released with effect from 31/5/2022. That is the status of the petitioner.
Annexure 3.
Yes, my lord. And then as stated, the petitioner 1 is solely created by the governed by the OM 17/3/2015, which clearly states that an employee, a workshop employee on scale, if it served 30 years on scale, he will be entitled for service regularization. Since this state respondents didn't have much objection regarding the petitioner number 1, your lordship, I'll just end my petitioner number 1 submission here. Now the petitioner number 2.
What about 2?
Petitioner number 2, he was appointed as work charge jocator on scale B, page 16, annexure 4. Type copy is at page 17, my lord. May I read the office order, my lord?
Yes.
In the interest of public service, Shri Yalam Konyak, son of Mr. Tangnao Konyak, is hereby temporarily appointed as work charge jocator in the scale of pay, plus all other allowances as are admissible under rules of Nagaland from time to time. Appointment order is on 10 June 1980. And after that, the petitioner was again promoted to the post of Federal Grade 2 by Annexure 5, page 18. Type copy is page 19. Office order dated 31st October 1986. In the interest of public service, the following servants are hereby promoted to work charge Federal Grade 2 in the scale of pay rupees such and such on work charge basis with effect from 21/11/1986. Thereafter, after serving for more than 30 years, the petitioner, he was released from service on attaining the age of 60 years by office order dated 7 June 2011, Annexure 6. This is the release order. Page 20, the petitioner is its serial number 3, my lord.
This is petitioner 2.
My lord.
Petitioner number 2.
And then the petitioner number 2 is listed its serial number 3 at Annexure 6, page 20, that is order dated 7 June 2011. May I read the order, my lord?
Yes.
Order dated 7 June 2011, in terms of Section 3, Subclause 1 and Section 3, Subclause 2 of the Nagaland Retirement from the Public Employment Second Amendment Act 2009, which comes into effect from 31st October 2009, in terms of Government of Nagaland BNER Department Notification Number, such and such dated 7 August 2009, the following 5 work charge employees under BHE Department whose names in particulars are shown below are hereby released on superannuation on completion of 60 years of age with effect from the date as indicated for each. Serial number 3, Office Division Mon, name Yalim, that is petitioner number 2, code number Mon 0306, designation Federal Grade 1, date of first joining 11/6/1980, date of superannuation 09/06/2011. So, after retirement, accordingly, as per the instruction of the petitioners, I have submitted a representation annexure 8, page 22. To the Chief Engineer PhD Nagaland Kohima, seeking for service regularization. But due to non-compliance, the petitioner is before this court.
What have they said in their affidavit?
In your
What do they
affidavit,
say?
yes.
The main ground page.
Paragraph 4.
Yes, Lordship, we have not objection of the petitioner number 1 case, Lordship. Yes, already forwarded to the government via letter dated 17/11/2020, Lordship. How Lordship, Lordship, kindly come to paragraph 4 of my affidavit, Lordship. That with regard to the statement made in paragraph 2 of the writ petition is admitted to the extent borne by records. However, it is pertinent to state that Office Memorandum dated 17/3/2015 was effective from the date of issue of the Office Memorandum and not with retrospective effect. Therefore, petition number 2, those served for more than 30 years will not be eligible for regularization. As per the Office Memorandum dated 17/3/2015, as he was released from service via an order dated 7/6/2011 for the implementation of the regularization scheme of Office Memorandum dated 17/3/2015. Hence, the petitioner cannot claim benefits under the scheme. Lordship, we also kindly come to point number 6, last paragraph. Whereas in regard to petitioner number 2, he was retired on 7/6/2011 and the Office Memorandum dated 17/3/2015 was issued after the retirement of the petitioner. Therefore, the petitioner number 2 will not be covered by the Office Memorandum dated 7/3/2015. Furthermore, he never approached the department for regularizations during his service. He submitted his representations only on 15/10/2024, after 13 years of his retirement. No explanations or reasons are stated by the petitioner for the delay. It is a well-established principle of law that unreasonable delay in wages is incurable. Therefore, the present case in regard to the petition number 2 is fit for dismissal, Lordship. Lordship, to supplement my submission, I would also like to place this order dated 24/10/2024. I understand with petition that this
Similarly situated.
Lordship, on the ground of delay in wages, this honorable court has dismissed, Lordship.
Yes, have you seen this order?
Yes, my lord.
Here also, similar, he also superannuated on 31/7/2011. So here also in this present case, his date of retirement is
2011.
2011. From 2011
And he came to court only
till 2025.
Yes, my lord.
What was he doing?
Lordship, regarding that, I will satisfy this honorable court, your lordship. I have a similar case, which was passed by this honorable court also on the ground of delay in wages. And then secondly, similar statuted employees, those who were much junior to the petitioner, were also regularized. That means, which means to say that the department, they are knowingly denying the rights of the petitioner, leaving behind the rights of the petitioner.
But did he ever represent?
No, Lordship.
Before retirement?
He did not.
No.
He did not.
Before retirement, he never represented Lordship.
And his first representation is this one, which is enclosed, isn't it?
Yes, my lord.
2024.
Yes,
First
my lord.
representation in 2024. So how can the court help someone who has been sleeping? Yes, para 6 you were referring to.
The last paragraph is
Third
indicated
on.
petition number 2. It's retired.
Retired on 7/6/2011 and okay. Petitioner number 2, I don't think this court will be able to help.
Lordship.
Yes. Petitioner number 2's case,
Yes, Lordship.
I think cannot be considered.
Then, Your Lordship, in that case, if I may, petitioner number 1, since they've already admitted, I'll be covered by the voice
Yes,
OM.
yes.
For that, I don't have any much more submission. Then, regarding petitioner number 2, if direction may be given to the respondents to dispose my representation.
This representation.
Yes, petitioner number 2 representation. That will really help for yes, my lord.
Will dispose accordingly then.
Yes, Lord.
Allow in respect of petitioner 1 and in respect of petitioner 2 direction to dispose of that his representation.
Yes,
That
petitioner's
2024
earlier representation.
representation.
Page 5 of marriage petition, for the petitioner details are right in here.
Page 5.
Page 5, my lord.
The name of the petitioner 2 is
Shiri Yalam K.
heard learned counsel for the petitioner, Mr. Sepungwati Wali. Also heard Ms. Pichanu Kitan, alternate government advocate for the state respondents. Stop. Para. The instant writ petition has been filed by 2 petitioners, namely Shri
Chinke.
Chinke, CHENGKEA, Chinke and Shri Yalam, YALEM, Yalam.K, praying for regularization of their service in terms of the office memorandum number AR-3/GEN-201/2009 open bracket PT close bracket dated 17/3/2015 on the subject scheme for regularization and absorption of work charge and casual employees and revision of pay/wages. Stop. Para. The petitioner number 1, Shri Chenke, was appointed as work charge labor under the establishment of the Executive Engineer PhD, Mon, Nagaland, with effect from 10/5/1987. And later on, his post was upgraded to work charge Khalasi with effect from 14/1/2022. 2020 on Scale Bay by Office Order Number CE/PHE/WC/EST-1/456/460 dated 15/1/2020. Stop. After serving for 35 years of service, he was released from service with effect from 31/5/2022 by Office Order Number EE/MEST-3/WC/2006-07/986-991 dated 30/5/2022. Stop. Para. The petitioner number 2 was appointed as work charge Chokidar in Scale Bay by an office order dated 10/6/1980 and thereafter by another office order number EE/PHE/M/WC/E, this is EL or E1, E1-1/PT-1/86-87/116-20 dated 31/10/86. He was promoted to the post of fitter grade 2 with effect from 21/11/1986. So, after serving the department for 30 years, 5 months and 9 days, the petitioner was released from service by Office Order Number CE/PHE/EST/4/74/689-96 dated 7/6/2011 on completion of 60 years of age. Stop. Para. It is the case of the petitioners that the petitioners have fulfilled the criteria provided in the scheme, that is, i.e., OM dated 17/3/2015 for regularization of service issued by the state respondents. Stop. The petitioners had also submitted representations dated 23/10/2024 and 15/10/2024 respectively to the Chief Engineer PhD, Nagaland, praying for regularization of service, but the same has not been considered by the authorities till date. Stop. Para. Learned Counsel for the petitioner submits that the office memorandum dated 17/3/2015 notified by the government of Nagaland has made it clear that all existing work charge and casual employees of various departments who are enjoying scale pay and have completed 30 years or more of continuous service as on 1/1/2015 will be regularized by conversion of their post into regular ones personal to them. Stop. Para. It is therefore clear that the petitioners have served the department for more than 30 years and 30 years, however, after their long devotion and dedication to their work, the petitioner's services has not been regularized in terms of the office memorandum of 2015. It is submitted that the petitioners are eligible under the said office memorandum, and therefore it is prayed that this court may direct the respondents to regularize the petitioner's service under the office memorandum dated 17/3/2015. Stop. Para. Learned Government Advocate Ms. Bichana Kitan, appearing for the state respondents, has fairly submitted that the petitioner number 1, Shri such and such, where is that in your affidavit that he is eligible? Petitioner 1?
Page 3, paragraph 6, Lordship.
That the case of the petitioner number 1 / his name, okay, was forwarded along with similarly situated cases to the government via letter dated 17/11/2020, and the name of the petitioner is reflected at serial number 38 under Mon Division. Stop. It is also stated that the process of regularization of work charge employees has to go through various stages, i.e., the Personnel and Administrative Reforms Department clearance, Finance clearance, Manpower Rationalization Committee clearance, and finally Cabinet approval. Stop. Therefore, the case of the petitioner number 1 will be considered will be regularized as and when his case is cleared by the above mentioned departments. So his case is under process. Stop. And therefore it is submitted that the case of the petitioner number 1 is already being processed and is under consideration of the state respondents. Stop. Para. As far as petitioner number 2 / Yalam K is concerned, the Learned Government Advocate submits that the petitioner number 2 retired from service on 7/6/2011, and only after his retirement the office memorandum dated 17/3/2015 was notified by the state respondents, and therefore the petitioner number 2 is not covered by the office memorandum dated 17/3/2015. Stop. It is further submitted by the Learned Government Advocate that during his service he never approached the department for regularization, nor did he submit any representation, and his first representation was submitted only on 15/10/2024, after 13 years of his retirement. Stop. The petitioner number 2 has also not given any explanation or reasons for the delay, and therefore the case of the petitioner number 2 is defeated by delay and laches as well. And the Learned Government Advocate submits the praise that the case of the petitioner number 2 may be dismissed. Stop. Learned Government Advocate has also relied on an order dated 24/10/2025 passed by a coordinate bench of this court in WBC 218/2025, wherein this court had not entertained the petition filed by the petitioner, as the petitioner in WBC 218/2025 had also retired on 31/7/2011, and he had never approached the authorities during his service nor submitted any representation for regularization. Stop. the petitioner had submitted his first representation to before the authorities only on 16/5/2025. Stop. And had approached the court in the year 2025. Stop. This court, after considering the facts of the case and after hearing the parties, dismissed the writ petition on the ground of delay and laches, as the petitioner had not approached the court on time. So, learned government advocate submits that the present case is also present case of the petitioner number 2 is also squarely covered by the facts of the petitioner in WPC 218 of 2025. And for the sake of propriety, similar order may be passed in the present case also in respect of petitioner number 2. So, this court has given its due consideration to the submissions made by the learned counsel for the parties and has perused the pleadings and has also taken note of the order passed in WPC 218 of 2025. Stop. Para. As the state respondents have fairly admitted that the case of the respondent of the petitioner number 1 is already under consideration by the authorities for his regularization, this petition is disposed of in respect of petitioner number 1 slash his name, what was his name? CHENGKEI, with the direction to the respondents to finalize the entire process in respect of the regularization of the petitioner number 1 within a period of
5 months.
Within a period of 5 months from today. 5 months from today. Stop. Para. In respect of petitioner number 2, it is observed that the respondents have not disposed of the representation submitted by him on 15/10/2024. Is that right? 15/10/2024. Stop. Accordingly, the respondents are directed to dispose of the representation of the petitioner number 2 dated 15/10/2024 by passing a speaking order, With the above directions, the petition stands disposed.
Lordship, if regarding the petitioner two representation, if a time period may be given, at least 45 days for disposing the representation.
Yes, the representation of the 2 within a period of 2 months, by passing a speaking order.
Obligation.
For unlisted motion, WPC 32 of 26.
May it please your lordship. One of the challenges, my lord, the seizure made by custom authority on the ground, my lord, the goods carrying vehicle.
Notice you have given.
Yes, my lord, we have given.
Okay.
Seizure are suspected to be of foreign origin. Subsequently, what has happened, your lordship? When we approached the custom authority for release of my goods, the region assigned by custom authority is now different. At the time of seizure, the inventory, they are saying it is suspected to be foreign origin. But in the release order, which was rejected, saying that since e-way bill under section 68 and 138 rule of GST Act was not there. That's why it was detained. Goods were. My humble submission is, my lord, I will come to documents, my lord. My lord, different works are, my lord, assigned to the different department, my lord. Regarding, my lord, foreign origin and all, custom is the authority. My lord, regarding GST, my lord, GST Self-Content Act is there. There are provisions to impose penalty, tax and all. But, my lord, one cannot trench open a power which is reserved for other authority, my lord. If now, my lord, kindly come to first page 50, my lord, inventory. And my lord will kindly see
Page 50.
page 50, my lord. Place and date of seizure, serial number 3. Initially detected at Lamding Hojai on 6/11/2025 at around so and so, and formally seized at Custom Division Dimapur on so and so. And thereafter, serial number 1, my lord, kindly see. Number of packages 480 bags. Detail of description of goods: Areca nut, supari, suspected to be of foreign origin. So, my lord, under section 110 of Custom Acts, my lord, if the commissioner has, that I will place, my lord, reason to believe that the goods are to be, my lord, confiscated. In that case, my lord, seizure can be done. But he has to give full details, my lord. My humble submission before your lordship is, my lord, at the time of seizure, the preconditions as prescribed under section 110 are not complied with. So, my lord, the seizure is illegal at the time of seizure itself. Now, my lord, kindly come to their reason, my lord, page 56.
Yes.
Page 56, my lord, Annexure 6. May I read, my lord? Please refer to your application seeking provisional release of the seized so-and-so, vehicle number so-and-so, dated so-and-so. The matter has been examined with reference to the provisions of Customs Act. My lord, kindly. And CGST. My lord, my humble, that I will place judgment, my lord. Custom authority has not been empowered to deal with the matter relating to CGST. Thereafter, it is observed that at the time of interception, the vehicle was transporting goods without generation of valid e-way bill. As per section 68 of the CGST Act, read with rule 138 of the CGST Act, generation of an e-way bill is mandatory for movement of goods, irrespective of the nature of supply. Even for a self-transportation between two godowns, following documents are required. In the present case, your lordship, petitioners were carrying goods from Hailakandi, my lord, to the destination of Gauhati. It was stock transfer, meaning thereby, my lord, it was transferred to his own godown. It was not for the purpose of, my lord, sale and supply. And as per GST Act, my lord, levy can only be made if the goods are being sent for the purpose of sale and supply. In the present case, the question of sale and supply doesn't arise. They are admitting. Accordingly, it was dismissed, my lord, rejected. My lord, page 58.
Yes.
Well, this is a circular issued by Government of India, Ministry of Finance, Central Government Board of Excise and Customs, GST wing, GST policy wing. And at the table, my lord, a subject proper officer relating to the provisions of other than registration and composition under such so and so. And serial number 2, my lord, kindly see.
Additional or joint commissioner?
My lord. Not, my lord, superintendent of custom. Because the seizure power subsection 1, 2 and 5 and 9 of section 67 empowers for empowers my lord the authority to seize it.
Proper officer relating to provisions of registration.
And relating to my lord, page 61, relating to my lord seizure and all, there is a procedure prescribed by the my lord central authority, my lord. And it is in respect of the GST authority, not the custom authority. Now, my lord, kindly come to first section 110 of Customs Act. Then I will place judgments, my lord. 110.
Seizure of goods.
My lord. In respect of custom. May I read, your lordship?
Yes.
My lord. Seizure of goods, documents and things. If the proper officer has reason to believe that any goods are liable to confiscation under this act, he may seize such goods. My lord, there is no whisper that goods so seized are for the purpose of confiscation. Subsequently, in fact, they have changed their stand by saying that e-way was not there. Thereafter, my lord, provided that where it is not practicable to seize any such goods, the proper officer may serve on the owner of the goods an order that he shall not remove part with, otherwise, my lord, it is not applicable. Thereafter, my lord, clause 1b say, wherein goods being so specified under section so and so have been seized by a proper officer under subsection 1, he shall prepare an inventory of such goods containing such details relating to their description, quality, quantity, mark, numbers, country of origin, and other particles as the proper officer may consider relevant to identify of the goods in any proceedings under this act, and shall make an application to a magistrate for the purpose of, my lord, certifying the correctness of inventory and all. So, initially goods were seized only on suspicion that it is of foreign origin. Well, though there are no material, in fact, as per section 10, he has to write, my lord, from which origin it was coming. Simply saying that it is foreign origin, my lord, suspected, that too suspected. And Apex Court says reason to believe cannot be on the basis of suspicion. My lord, I am placing certain decisions
No,
of...
the intention may have been to confiscate.
Confiscate.
But the only thing is procedurally.
My lord, I am on that, my lord. I am coming to, my lord, certain decisions, my lord. It may help your lordship.
No, at this stage we'll issue notice only.
My lord, I am praying provisional release.
No.
My lord, what I am praying...
No, that will frustrate the entire
True.
petition.
What for their interest, what I am suggesting, my lord, what I am suggesting...
Short notice.
My lord, what I am suggesting, my
The
lord.
entire petition will become infructuous if the...
True,
interim is
no, my lord,
granted.
if the seizure, your lordship will held that seizure is illegal. In that case, my lord, the situation would have been different. What I am suggesting, my lord, they are also interested with, my lord, tax.
Because the senior counsel is also not there.
But, my lord, by that time, good, so, two months there.
Short notice, 2 weeks. 2 weeks notice.
Perishable, my lord, it will be...
No, it is not areca nut, it is not very...
But, my lord, after some time, some fungus and all, it will come.
2 weeks, it will not happen. 2 weeks only. Okay, 2 weeks. within
Otherwise,
2 weeks,
I am ready
this
to
is
pay
only
tax.
for the interim consideration.
Or we can execute...
Just call.
Otherwise,
No, learned counsel, I understand.
My lord.
Maybe some procedural defects may be there.
Right, my lord.
But then the whole petition will become infructuous if the interim is allowed. So we'll see. It can be disposed of also on the next date. But for the interim
If they obtain
consideration-
instruction, it may be taken tomorrow, my lord. If they obtain instruction.
I don't think tomorrow. Head learned counsel for the petitioner, Mr. I forgot.
A. Goel,
his
my
name,
lord, Amit Goel.
Yes, A. Goel. And also heard Miss such and such appearing on behalf of Mr. Gauhati, the learned CGC, for respondents number. For all the respondents.
Just one.
One.
Other custom and all?
Oh yes, they have counsel.
We have counsel. We have posed the counsel. What I can custom and GS. Oh, he refused.
Oh. For respondent number 1 only then, 1. The present application, the present writ petition has been filed by the petitioner alleging violation of section 110 of the Customs Act 1962 by seizing his goods without fulfilling the preconditions directed in the said provision. Stop. The petitioner has also alleged unlawful detention / seizure of the goods by the customs authorities by usurping the power specifically reserved under the Goods and Services Act, under which only the additional or joint commissioner of central tax is empowered. Stop. Issue notice returnable within 2 weeks. Stop. The learned counsel for the petitioner shall take steps for service on the respondents number 2 to 7 by inland speed document as well as usual process within 3 working days from today. Stop. On the next returnable date, the prayer for interim order shall be considered. That will do.
My lord, in the meantime, they may not confiscate, my lord, that much, my lord. Otherwise,
Okay. It is also directed that till the next returnable date, the goods belonging to the petitioner may not be confiscated.
date may be fixed, my lord, if not inconvenient.
After 2 weeks. no?
After 2 weeks, my lord.
Today is 19th, so
Be on second.
no.
12, my lord, 12.
Today is 16th, no? So 1, 2. Okay, 12th. 12th March. You get instructions, okay? Yes,
Deeply obliged.